standing.
Yes.
But suppose it is starting off as a, what is that, extra neutral alcohol producing, and then eventually subject to demand, let us say, you are in that industry, extra neutral alcohol, you are up till the state is still then in control. Thereafter, depending upon how, at the point of removal, what extent you are removing, then state and union control will come in. That's what I think Justice Jeevan Reddy had said.
Yes. But your Lordship, answer is, in your Lordship's example, my final product will say ENA, extra neutral alcohol.
Your final product will say.
My license will say extra neutral alcohol. I have to get permission from the state distillery.
Right.
But if I'm going to make MEG, or if I'm going to make alcohol-based final products, because there's a host of final products which can be based out of alcohol, then I will go for an excise license or now a GST license, and I will never come within the purview of the state law, because I'm never making ENA at all. I'm never clearing ENA.
That time you are adding the denatured elements.
Yes, there my final product is potable alcohol. That's why what they say is intoxicating liquor is intoxicating liquor. To the extent you denature it, it doesn't cease to be intoxicating. It becomes unfit for human consumption.
That is a little area of divergence between you and Mr. Giri's.
Lord, I would still stick to the submission, Lord, with respect.
Yes.
Lord, para 3 of
But only thing, Lord, we both say I'm under state control. So we are denatured. Here I'm under state under entry 8. He's under state in entry 33. But your Lordship's answer is correct. If the center is notified, then under Mr. Giri's argument, denatured will come under central control.
Right.
Under 18G.
Yes.
Lord, subpara 3 of para 23 of Bihar distilleries deals with this aspect. I think when your Lordship said integrated, Lordships had in mind a case where up to the stage of protection of extra neutral alcohol, Lord, there is no divergence. But after ENA comes into being, part of it is may not diverted for an industrial purpose, either by denaturing it or may not for whatever the process, it has to be denatured. It then becomes industrial alcohol. Justice Jeevan Reddy's judgment, my lord, also speaks about a case where without denaturing it, it is still treated as industrial alcohol because it is not meant for potable purposes at all. In my respectful submission, since ENA is also, my lord, alcohol, which would come under entry 8, it is not inconceivable, my lord, that the state may come out with a, my lord, like in, my lord, intermediate products could also be subject, my lord, to an excise duty or a levy. And therefore, ENA is an intermediate product and not the final product as such. ENA could be subjected to. But where the ENA goes into the manufacture of potable alcohol, I don't subject it to an excise duty at the stage of ENA. I'll probably reserve my right to do it after the final product comes out. But why should I lose out? Why should the state lose out if the control comes under entry 8? And it says production, manufacture. Manufacture is always not conceived as the final product. Production is of an intermediate stage. And if therefore extra neutral alcohol, even if it is 95% as mentioned in para 74 of synthetics and chemicals, is still a product which is covered by entry 8. I would not by lose my right, not even under entry 8, to tax it before it is cleared, not for industrial purposes. Therefore, my lord, this is my respectful submission. To that extent, subpara 3 or the paragraph 23 may be, my lord, modified by your, in Bihar distilleries also should be modified by your lordships. It's my respectful submission. My lord, just one more aspect, my lord, and I'll complete it. In synthetics and chemicals, my lord, and why? Synthetics and chemicals is 1990 1 SEC, page 1. 1990 page 1 SEC. Give the citation for synthetics. 109. Lord, it's in volume 5, page 9, PDF page 9. Lord, Lordships may come to paragraph 74 at PDF page 54. Going to that's it. My Lord, the objectionable portion, my Lord, if I may say so with respect.
Page 50.
PDF page 54, paragraph 74. My Lord's got it. Your Ladyship has it?
Yes.
It has to be borne in mind that by common standards, ethyl alcohol, which is 95%, is an industrial alcohol. This, my Lord, we would respectfully submit. We would most respectfully urge requires reconsideration. Why, Lord, why should it be a question which I ask unto myself is, why should it be treated as an industrial alcohol? It's extra neutral alcohol with a higher strength. It can be used for human consumption. Of course, my Lord, by tempering it with water or by any other substance as such. But there is no question of, my Lord, it becoming irretrievably unfit for human consumption. That happens only on denaturing. The petitioners and the appellants were manufacturing ethyl alcohol, also known as rectified spirit, fair enough, which is an industrial alcohol. My Lord, that doesn't go as a sequitur. ISI specification has divided ethyl alcohol into several kinds of alcohol. Beverage and industrial alcohols are clearly and differently treated. Rectified spirit for industrial purposes is defined as spirit purified by distillation having a strength not less than 95% of volume by ethyl alcohol. Dictionaries and technical books would show that rectified spirit is an industrial alcohol and is not portable as such. But then where is a reference, my Lord, to the legislations which were existing from 1880 onwards? It appears therefore that industrial alcohol, which is ethyl alcohol, by itself is not only non-portable but is highly toxic. The range of spirits of portable alcohol is from country spirit to whiskey, and ethyl alcohol content varies between 19 to 43%. These standards are according to the ISA specifications. In other words, ethyl alcohol 95% is not alcoholic liquor for human consumption, but can be used as raw material input after processing and substantial dilution in the production of whiskey, gin, country liquor, etc. Entry 8 relates to production also. Lord, why should ethyl alcohol at 95%, which is one of the raw materials, or which is used as a base for preparing different varieties of Indian-made foreign liquor or country liquor for that matter, where only there is a dilution by addition of water, why should it fall outside the purview of alcoholic liquor for human consumption as mentioned in entry 8? But can be used as a raw material input after processing and substantial dilution in the production of whiskey, gin, country liquor, etc. In many decisions, it was held that rectified spirit is not alcohol fit for human consumption. Reference may be made in this connection to so and so, so and so. In this connection, it is important to bear in mind the actual provision of entry 8 of list 2. Entry 8 of list 2 cannot support a tax. The above entry contains the word intoxicating liquor. The meaning of the expression intoxicating liquor has been rightly interpreted by the Bombay High Court in Balsara. The decision of the Bombay High Court is reported in so and so. In that light, perhaps, the observation of Justice Fazal Ali in Balsara's case requires reconsideration. It appears that in the light of the new experience and development, it is necessary to state that intoxicating liquor must mean liquor which is consumable by human being as it is, and as such, when the word liquor was used by Justice Fazal Ali, they did not have the awareness of full use of alcohol as industrial alcohol. The point is not that, to put us on the other foot. Can it be used as portable liquor? It is true that alcohol was used for industrial purposes then also, but the full potentiality of that user was not then comprehended or understood. With the passage of time, meanings do not change, but new experiences give new color to the meaning. In Harshankar's case, a bench of 5 judges have surveyed the previous authorities. That case dealt with the auction of the right to sell portable liquor. The position laid down in that case was that the state had the exclusive privilege or right of manufacturing and selling liquor, and it had the power to hold public auctions for granting the right or privilege to sell liquor, and that traditionally intoxicating liquors were the subject matters of
And
That is Mr. Dwivedi's submission also.
yes, originally Mr. Dwivedi.
Relying on Balsara.
Yes, Balsal. Second submission as well as that entry 51, the entry 52 of list 1 is not a unblocked entry. It is blocked and a specific purpose controlled by union of an industry. A law is to be made, which is the IRDA.
Not what do you,
I'm sorry.
not an unblocked entry. What do you mean?
Yes, unblocked means it's not an unbridled power that in regard to any industry, the union can make. That power is in 24. Union need to make a law to take control of that industry, the law pertaining to take control, and that's section 2 declaration of the IRDA. If I can read quickly the entry itself, my lords have seen on numerous occasions. Industry, the control of which by union is declared by parliament. It is not simply considered industry.
Right.
And otherwise, the industry is covered under entry 24 of list 2, Malas.
That is the point. What is the nature of industry under which the parliament can make?
Yes, Malas.
You have rightly said fermentation industries.
Yes.
Even if you see this 26 fermentation industry, there is a twofold classification.
Yes, Malas.
One, it is alcohol. The other is
Others.
other products of fermentation industry. Under alcohol, they have again made a classification. Alcohol which is potable,
Yes.
alcohol which is not potable.
Yes, Malas.
That means it's an indication
Yes.
that alcohol is potable only is under entry 8.
Malas, the
Anything not potable,
yes.
the parliament has the powers in view of entry 52 list 1 and entry 24 of list 2.
My respectful submission, Malas, even if we look at that indication sum which has been given, if it is an industry specific and a product which has been already given entry 8, will that entry given in that schedule will exclude one of the product out of the product which has been given in entry 8? With great respect, and one of the
It is not the product, it is a classification of a product.
this is the subject matter. The subject matter of framing law.
But then Mr. Balvi Singh,
Yeah.
your submission is not at variance with what Mr. Datar or Mr. Dwivedi argued. Because their contention also was that denatured spirit also
Yes.
falls in entry 8, step 1.
Yes.
Because it falls in step 8, in entry 8, it can't fall in entry 24.
Yes.
Right?
Yes.
Because following Calcutta gas.
Yes.
If it can't fall in entry 24, there's no question of it being taken out for the purpose of entry 52.
Yes.
Right? That was the line going
What
from
submission
entry
is that?
8 to entry 24 to entry 52, and therefore, according to them, this retains the power of the state under entry 8.
Yes.
So your submission is not different from that.
Effectively not different, but I am trying to take maybe a step prior to that.
Content of entry 8.
Intoxicatedly.
So I'm only on the subject matter, Malas. I'll just rely on 2 judgments.
I think that, while entry 8 is product based, entry 52 is industry based.
Industry based, Malas. And today
There's an answer to it that, entry, IDRA is both product based and industry based. In section 18G, it's product based. There are some parts of it which are industry based, of course.
today when we look at the declaration which is given in section 2, the similar declaration, I can quickly tell the facts of this case before. In Karnataka, the contract carriage was nationalized. In 1976, law was framed, and all private contract carriage was taken control of by the government by a law. This was in 1976, went to Supreme Court. Supreme Court identified 7 judges before this court, and court said that state is competent, identified the entry with the acquisition and requisition entry in entry 42 in concurrent list. Not tracing to industry, but tracing to saying that the acquisition of property or acquisition of property in 42 is there. 1988 Motor Vehicle Act came in. One of the parties went to the state authority RTO saying that now the 1988 Motor Vehicle Act has come, please give me the registration or license. This issue came to the Honorable Court again.
There the issue came that 1988, a Central Act has come in, and therefore these provisions are in conflict. Looking at this provision, and the Motor Vehicle Act was also traced to entry 35 of concurrent list. So both the conflicting entries were in the state list. This honorable court said that just to explain, the entry 35 was pertaining to mechanical vehicles. So therefore, two conflicting entries were requisition and acquisition of property and mechanical vehicle. These were two conflicting entries for Motor Vehicle Act of 1988 and 1970, the acquisition law. This honorable court said, if the subject matter is not the same, even if there is an overlap, then independently they can prevail. Today, to oust the jurisdiction of the state by carving out the denatured alcohol out of entry 8, relying on a product given a schedule with respect, this is an independent subject. There the industry has been defined. That's what he argues.
No, I think we'll conclude at this point. We take Mr. Saraswat. Yes, Mr. Saraswat. Thank you, Mr. Balbir.
Just one part I want to read. From the IS, Mr. Giri argued that so far as the state of Kerala is concerned, that the denatured cannot be converted to renatured. BIS standard, which in para 74, which been looked into in synthetics, simply said anything over 95% is industrial alcohol, although it should denatured. This was taken note of by BIS standards. I have placed on record. I'll give the page numbers also. They clearly noted that there can be a complete denaturing, there can be a special denaturing. As a matter of fact, where the government has faced a problem is special denaturing, which can be again converted into renaturing, because this was specified for some 25 industries. And there are live experiences that has been converted and sold in the market as a country liquor. Based on that finding, it has been given that the BIS standard which are given is in straight conflict with para 74. That's been a forward which has been by BIS which has been given. So therefore, Mr. Datar pointed out,
in the case of a special denaturing,
yes,
capable of being used again, is capable of being denatured.
Yes, and it's a only boiling point is to be changed. They note that it's a very simple process, and they specify also industry. If my laws permit, I can quickly show that BIS standards which have prescribed this. And as a matter of fact, they said it's been happening. And they specified even what is the boiling point and what the changes going to take place. I just quickly show only one page and then I'm done with that. I filed my written submission in volume IK, and 1K, sorry. And page 129, which is PDF 129, PDF 130.
BIS standard. What are you referring to?
I'm referring to only the forward of those standards where this problem was specifically noted, and what is the...
Where do we get it? Volume?
Volume 1K, PDF 130, 130.
No, it's not there.
I can quickly read that. There's only 2 paras. I can just quickly read. The third para, completely denatured alcohol, which is CD, and specially denatured alcohol ST formulations are set out in this standard with a specific composition. Both CD and ST formulations are made from the spirit in accordance with the international trade practices. These resulting products are not fit for human consumption. Instead, the products are intended for industrial use. CD, that is completely denatured alcohol, is composed of alcohol and specified denaturants that cannot be easily removed by a simple process and can be used in number of industrial use. As the denaturants cannot be easily or economically removed, CD is considered to be low risk of diversion or abuse. ST, which is the specifically denatured alcohol, is composed of alcohol and specified denaturants that are more readily removed by simple chemical process, while specifically denatured spirit is not fit for human consumption by virtue of denaturants used to denature the product. It can, through certain recovery process, be made portable. As a result, its use is controlled through the registration of users, like the paint industry. Otherwise, everybody user is going to go out Today, there is no mechanism by virtue of which the user industry, what they do with the denatured spirit which they procure. There is no control except the state laws which are controlling, like through licensing, returns filed by them. There is no law which prevails. And just one more page on this, how the formula of these two are given, and look at the extent by which these two type of categories of product, PDF 139. A category, the formula for denatured alcohol. A category is completely denatured alcohol, which are safe, are low in risk. Look at B, specifically denatured alcohol. These are the products which are there, and these are regularly being purchased and sold and consumed by the user industry models. And this is under the high risk, as a matter of fact, which has been found to be a problematic area.
Genuinity in making what is non-portable portable.
Yes, but as a straight, I asked this question that why somebody is going to do this. The 350% of the excise duty is saved straight on this line.
Intoxicating. Even plastic soda.
Medical products like cough syrup.
You're done now?
Yes.
Thank you. So, Mr. Paras, we'll take your submission. 15 minutes or so. You can argue to your heart's content, but about 15 minutes. क्या बहस करेंगे?
हाँ सर.
Yeah.